Good afternoon. My name is Lenny Cheng, and I will be presenting on the barrister's ethics. Today, we will be going through module number 1, which is just the introduction. I'll be working directly off of this PDF file, which is the Legal Professional Uniform Conduct Barristers Rules 2015. Now, this is adopted under the Legal Profession Uniform Law Application Act 2014. I will be referring to this act rather than saying Legal Profession Uniform Law Application Act the whole time. I will be referring to this act as the act or the statute. And I'll be referring to the rules instead of saying the Legal Profession Uniform Conduct Barristers Rules 2015 the whole time. I will be calling this the rule book or the rules. So I hope that's clear. I prefer to work off the PDF file itself. We'll be going through it together, and I'll be making notes on the PDF. I find this better than doing PowerPoint slides and copying, pasting the content over and doing 50, 100 slides. This is much easier. It gets to the point as well, especially on a topic so rule-stricken like ethics. If I do mention cases, I will drop some cases. If I do mention cases, then I will be pulling up the case itself, but I don't think so. This is really not required for your bar. For your bar, you'll only really need to reference the rules, and you need to do it quickly and efficiently. Time is of an essence, and also precision is paramount. The rest, such as the philosophy of ethics and the line of ethics and so forth, that you may have came past in other areas of law, is not required here. And even case law itself, we're not here to argue on ethics at this stage. It's pretty black or white. So there's 3 states that use this uniform law framework, which is New South Wales, Victoria, and Western Australia, who joined in 2022. So yeah, it's only applicable in certain states. Well, I would say all the states share a similar framework, but we're all sharing the same file for these 3 states. I wanted to work through this document together, if that's okay. Okay, let's begin. Introduction. Rule number 1, citation. These rules are designated as legal profession conduct rules and may be cited as Legal Profession Uniform Conduct Barristers Rules 2015. In terms of referencing, you would just call this Barristers Conduct Rules 2015 R and whatever number the rule is. So R24 and R23. Rule number 2, commencement. These rules come into operation the 1st of July 2015. Now, before 2015, state-specific professional conduct rules were enforced. So each state had their own system. And their bar association would then monitor what these rules were. But, there were key ideas such as duty to the court, independence of counsel, cab rank rule, confidentiality that were similar. So the uniform rules that we see here mainly standardized them across jurisdiction. We didn't really invent brand new ethics. We've just repackaged it so that across Victoria, New South Wales, and Western Australia, it is more uniform. This is not really needed. You won't be needed to specify the rules before 2015 unless you are writing an academic paper on the history of ethics. Rule number 3, objects. The object of these rules is to ensure that barristers, A, act in accordance with the general principles of professional conduct. So that means that barristers must maintain integrity, honesty, and fairness in professional practice. That's what it means by general principles of professional conduct. This is supported by, the case Gianarelli v. Roth, and I will write it here. I'm going to spell it out for you. So pretty much in this case, the High Court recognized that there was, special ethical responsibilities of advocates. And the reason why I brought this case up is because you may find that many of these rules, as much as it is an interpretation of the act itself, are also adapted with common law in mind. Okay, next, 3B, act independently. So this means that barristers must exercise independent judgment. And advocacy must not be influenced by client pressure, personal interests, public opinion. We will be going through this in more detail in Rule 23, which is duty to the court at a later stage. 3C, recognize and discharge their obligation in relation to administration of justice. Now, this means that barristers are officers of the court. So their role is not only to represent the clients, but also to assist the court in achieving just outcomes. And we will be talking more on this in Rule 23, which is duty to the court, and Rule 24, which is barristers must not mislead the court. And 3D, provide services of the highest standard, unaffected by personal interests. So that means that barristers must act competently and professionally. And personal interests must not compromise professional duties. And this includes financial interests, conflict of interests, and personal relationships with parties. Okay, just a quick note. You would have had a worksheet emailed to you. We will each, as specified in the email, each module, we will go through the worksheet together. So I would go through the answers at the end of each module, if that's okay. I find that works a lot better than waiting a whole week and then telling you your feedback then. Okay, Okay, now that that's out of the way, I want to go through 4. Now, 4 is actually the ethical backbone of the whole code. It's not the most important part that you're going to have to learn, but for this module, yes, it is. 4, principles. These rules are made in belief that A, barristers owe their paramount duty to their administration of justice. So this means that barristers' primary duty is to the court and to the justice system, and this duty overrides obligations to the client. So they must assist the court in reaching a just and lawful decision. And of course, this is related to, Rule 23, duty to the court, as we will go through later, and the Gianarelli case, where in the case, the High Court emphasized that the advocate's duty to the court and the administration of justice, was paramount. I think it was Mason CJ, which says that counsel owes a duty to the court as well as to the client. And yeah, he has a passage on it. I might put it up on the screen later. If you want to look more into this later, this is not needed for your bar, but this is just for your personal interest. 4B. 4B. Barristers must maintain high standards of professional conduct. Now, this means that barristers must act with honesty, integrity, and professionalism, and the behavior must be maintained in court proceedings, dealings with clients, dealings with lawyers, dealings with the court. Again, 4C, barristers are specialist advocates in administration justice and must act honestly, fairly, skillfully, bravely, and with competence and diligence. Okay, as you can see, there's a list of traits that you sort of really need to, or skill sets you really need to embody. Honesty, fairly, skillfully, bravely, and with competence and diligence. What does these mean, pretty much? So honesty means that you must not mislead the court or other parties. This is also emphasized in Rule 24, which states that barristers must not mislead the court. This is quite important. That's why I kept stressing. As you can see throughout the introduction already, we are constantly stressing Rule 23 and 24. Fairness. What does fairness mean? Fairness means that barristers must treat opponents, witnesses, and court fairly. And advocacy must not involve deceptions or abuse of process. And then what does skill mean? Skill means that barristers are specialist advocates and must exercise professional legal skill in representation. Bravery. Now, this can be often called as, often known as forensic courage. This means that barristers must advocate strongly for the client, even when their case is unpopular. And advocacy can't be influenced by fear of criticism, public opinion, or pressure. Anyway, next, competence and diligence. What does that mean? Barristers must perform legal work carefully and professionally, pretty much. And work must be prepared properly and conducted with reasonable care. Yes, there would be a lot of admin and proper handling of, statements, evidence, notes, proper transfer, handovers, proper filing of emails, all the rest. Now, next one. 4D, barristers owe duty to the court, to the client, and to their barristers and solicitor colleagues. So what does that mean? So let's look at duty to the courts. Duty to the courts mean that barristers must assist the court in the administration of justice. And this duty is paramount, meaning that this precedes their duty to the client. And again, Rule 23, duty to the court. Then they have a duty to the client. And barristers must represent the client competently and diligently, and must act in the client's best interests within the law. Such as they must prepare cases properly and give honest legal advice. Duty to other barristers. That means that they must maintain professional courtesy and respect in how they handle with other barristers. The bar operates as a professional community, so you must respect your learned friend. So this includes respectful advocacy, honoring professional undertakings and such. Duty to solicitors. What does that mean? So solicitor colleagues. So since barristers are usually briefed by solicitors, duties may include proper communication, cooperation in litigation, and professional respect. And we'll go to the next page. 4E. Barristers should exercise their forensic judgment and give their advice independently and for the proper administration of justice, notwithstanding any contrary desires of their clients. So the key concept here is independent forensic judgment, which means that barristers must form their own professional legal judgment. They must also give independent advice to the client and must also refuse instructions that would compromise their duty to their court. So pretty much a barrister must not be a mouthpiece for the client. So forensic here means relating to litigation or courtroom advocacy. It's not, really about CSI or anything like that. Examples of forensic judgment can be deciding which arguments should be made in court, advising whether a case should proceed, deciding which witnesses should be called, and determining how a case should be presented. These decisions are based on professional judgment, not client pressure. So one example would be a client tells the barrister, run this argument even though it's weak. So the barrister must decide whether the argument is legally proper and whether it is appropriate to advance. If not, the barrister must refuse to run it. So 4F, the provision of advocates for those who need legal representation is better secured if there is a bar whose members is 4FI must accept briefs to appear regardless of their personal beliefs. Now, 4E already reinforced this. We've kind of touched on this already. 4F sort of introduced the philosophical justification for the cap rank rule. Pretty much 4F is the philosophical justification for the cap rank rule. And as you can see, 4FI is already reinforced and by 4E that we discussed earlier. So that means that barristers must represent clients even if the client or the case is unpopular. Personal belief must not influence whether the barrister accepts the briefs. So we would discuss this further in Rule 17, which is the cap rank rule later on. Now, 4F2 must not refuse briefs to appear except on proper professional grounds. Now, what does that mean? That means that a barrister can't simply refuse a case because they dislike a client or issue. There needs to be proper grounds for a refusal, which may include conflict of interest, lack of competency in the area of law, unavailability, professional embarrassment. Again, we're going to discuss this further in Rule 17, the cap rank rule. And then 4F3, compete as specialist advocates with each other and with other legal practitioners as widely and as often as practicable. So what does that mean? That means that barristers operate as independent specialist advocates. They compete with other barristers and also with other legal practitioners. This stands on the idea that competition promotes high professional standards and access to advocacy services. So yes, they're promoting competition in this case, straight right in the rule. 5, interpretation. 5, interpretation. The interpretation of the Legal Act 1984 Victoria applies to the interpretation of these rules. This part is pretty much explaining who the rule applies to and when. It's more administrative than philosophical. 6, application of rules. Except as otherwise provided, these rules apply to a barrister whose practicing certificate is issued in a participating jurisdiction, except to the extent that the conduct of the barrister in relation to practice in a non-participating jurisdiction is regulated by barristers' rules for that jurisdiction. 6B, a barrister whose practicing certificate is issued in a non-participating jurisdiction in relation to practicing in a participating jurisdiction, including work wherever performed in relation to such practice. Pretty much, if you're holding a practicing certificate, you must comply with the Uniform Barristers Conduct Rules. It's definitely made to sound scary than what it is. Now, 6C, a barrister who is employed by the Crown or who holds a statutory office except that he or she is exempt from Rules 11 to 22 and 101 to 112 while acting pursuant to that employment or office. So this is an exception. If a barrister practices in a non-participating jurisdiction, then their conduct may instead be governed by the barrister's rules of that jurisdiction. So other jurisdictions, for example, are Queensland, South Australia, Tasmania, ACT, Northern Territory, which is, outside the uniform rules. Now, rule number 7. Other standards. These rules are not intended to be completed or detailed code of conduct for barristers. Other standards for requirements of and sanctions on the conduct of barristers are found in inherent disciplinary jurisdiction of the Supreme Court, the legislation regulating the legal profession, and the general law, including the law related to the contempt of court. So this pretty much says that the rules are not the whole story, and that barristers are also regulated by courts, legislation, and common law. Now we can go through our worksheet, if that's okay. I'm just going to pull it up right now. Okay, I want to go through example 1, independence from client pressure. So scenario, a client tells their barrister, I don't care if the argument is weak, run it anyway because it might confuse the judge. So what do you do in this case? Well, the barrister must exercise independent forensic judgment. And we spoke about this earlier in rule 4E. They must decide whether the argument is legally proper, whether it should be run in court, and if the argument is misleading or improper, the barrister must refuse. So we would apply in this case rule 4E, barristers must give advice independently, and rule 23, paramount duty to the administration of justice. I don't think we're going through rule 23 just yet. So in the paper, you wouldn't do like a deep summary. You just do as per rule 4E, barristers must give advice independently. So in this case, the barrister must exercise independent forensic judgment. And you will state what's required in the rule. Okay, example number 2, unpopular client. Scenario is a barrister is asking to represent a client accused of a very unpopular crime. The barrister personally dislikes the client and does not agree with their behavior. So what must the barrister do? Well, the barrister cannot refuse the brief just because they disagree with the client. That is written in rule 4F, as we discussed earlier. They must accept the brief if it is within their competence, if they are available, and the usual professional conditions are satisfied. So the rule applied would be rule 4F, that advocates should accept briefs regardless of their personal beliefs, and rule 17, the cab rank rule. Depending on the grading, because since this is just the first module, I'm just going to do a quick grading system where you just smash out what rules will be applied. But depending on the grading, if it is heavily weighted, then you may be expected to also say that in what circumstance can they refuse a client. But in this case, it's not, generally this exam is not going to be, a long one. So you don't need to look at every single possible counter argument as some exams do. Now, example 3, barrister must correct a misleading statement. So the scenario is during a hearing, a barrister realizes they accidentally told the judge something incorrect about a fact in the case. The judge has already relied on that statement. What must the barrister do in this case? Well, the barrister must correct the court as soon as possible because the barrister's paramount duty is to the administration of justice and not simply about winning the case. So we'll apply in this case Rule 4A, which is paramount duty to the administration of justice. And then later we will apply Rule 23 or 24, which is the duty not to mislead the court. Okay, example number 4. Client demands an aggressive strategy. A client tells a barrister, destroy that witness, accuse them of lying even if they're not sure. So what must you do in this case? Well, they must exercise professional judgment and they cannot make accusations without a proper basis. This is specified in Rule 4C, honesty, fairness, skill, and 4E, which is independent forensic judgment. And example number 5, barrister refuses a case for personal reasons. A barrister is asked to represent a person accused of terrorism. The barrister refuses because I don't want my name associated with someone like that. So what must the barrister be doing instead? Well, this is problematic. The bar system exists so that even unpopular litigants can obtain representation. And a barrister cannot refuse a brief purely because they dislike the client or the allegations. So the rules that we will use will be Rule 4F, which is acceptance of brief regardless of personal beliefs. And later on, we will discuss this further, which is Rule 17, the cap rank rule. Example number 6, barrister behaves badly in court. The scenario is a barrister becomes abusive to a judge during a hearing. So what should happen in this case? Well, they shouldn't do that, but what can happen in this case? Even if the conduct rules don't outright discipline or restrict this exact behavior, the court themselves can still discipline their barrister because the courts have inherent jurisdiction to regulate advocates appearing before them. They can discipline the barrister using Rule 4B, which is maintain high professional standards, and Rule 7. Other standards include Supreme Court disciplinary powers, the one we just went through last. Now, example 7, barrister has financial interests. A barrister owns shares in a company that is involved in a case that they are arguing. This is particularly worrying because their personal financial interests might also affect their professional judgment. So the rule book states that barristers must not provide services that are affected by personal interests. And this is governed by Rule 3D, which is services unaffected by personal interest, and then later conflict of interest rules. So that's that. I hope that's clear. That concludes the introduction part of our ethics module. So this will be separated out into multiple modules just to keep it nice and brief. And I will email out worksheets as we go along. So see you guys next week.